I drove 4 grueling hours up mountain roads to Grandpa's old cabin. Pine sap, stale coffee, still lingering in the wood. New chain-link fence cuts across my access. 6 spike strips behind it. 6 spike strips still lingering. In Crapple, Gram by HOA, vacate immediately. Boots on my porch. I look up. HOA president. Cold beer, smug grin.
Read the notice? This ain't your land anymore.
I don't argue. Nod once, turn the truck around, drive off slow. 48 hours later, I'm back. One single thing on the passenger seat. And somehow, the man who took my land is the one who ended up with nowhere to go. If this was you, what would you do in those 48 hours? Drop it below. Where are you watching from? HOA come for you yet? Let me back up, because this story doesn't make sense without a little history. And history, it turns out, is exactly what saved me. My name is Garrett, and I'm a third-generation owner of a 2-3-acre parcel in the Blue Ridge foothills of western North Carolina. My grandfather, a man named Eldon Marsh, bought that land in 1961 with money he saved working double shifts at a furniture mill in Lenore. He didn't buy it as an investment. He bought it because he wanted somewhere quiet to breathe. He built a 1-room cabin by hand over 3 summers, hauling cinder blocks up a logging road in a pickup truck that had no business climbing that grade. My father added a 2nd room in 1987. I added a propane hookup and a decent well pump in 2019. The cabin sits at the edge of a planned community called Ridgeline Estates, one of those developments that sprouted up in the early 2000s when some developer decided that nature was more profitable as a backdrop than as a wilderness. Most of the HOA lots are newer construction, vinyl-sided, pressure-washed driveways, American flags that never get taken down in rain. My cabin predates the HOA by 4 decades. That distinction would become the hinge on which this entire story swings. Now, let me introduce you to Sterling Briggs. Sterling moved into the largest lot in Ridgeline Estates in 2018, a 4,200 square foot house he did not build and, I would later learn, could barely afford. He was the kind of man who wore polo shirts to neighborhood association meetings and used words like aesthetics and property values, the way a hammer uses nails, on everything, constantly, whether it fit or not. Mid-50s, ex-middle management from some regional insurance company, the type of guy who had never had real authority in his professional life, and had decided, somewhere around age 52, that a homeowners association was the closest he was ever going to get to running something. Sterling became HOA board president in 2020, running unopposed because nobody else wanted the job. Classic. The first time Sterling came after me was the summer of 2021. He sent a formal HOA notice, on actual letterhead, with a seal, which should have been my first clue about how seriously this man took himself, informing me that my cabin's exterior lacked visual consistency with community standards. I ignored it. Then he sent a second notice with a $200 fine. I wrote back explaining, politely, that my property predated the HOA by 40 years and that under North Carolina property law, pre-existing non-conforming structures generally cannot be compelled into compliance with subsequently formed covenants. I used small words. He sent a third notice. This one included a photograph of my cabin circled in red marker, like I'd submitted homework he needed to grade. My neighbor Darlene, who has lived on her lot since 2003 and has the kind of institutional memory that small communities run on, told me at her mailbox one afternoon, the air smelling like fresh-cut grass and something sweet from her kitchen window, that Sterling had tried the same routine with 3 other homeowners. 2 of them caved and paid. 1 moved. Darlene told me this the way people tell you something important, slowly, making sure you're listening. He thinks the rules only work in one direction, she said, handing me a tomato from her garden. It was still warm from the vine. I should have listened harder to what she was really telling me. Because the following spring, Sterling didn't send a notice. He sent a surveyor, and then a fence crew, and then, with what I can only describe as the audacity of a man who has never once faced real consequences, he filed paperwork with the HOA claiming that my driveway, a 40-foot gravel strip, had been abandoned and therefore reverted to common HOA land. Then he had spike strips installed across it. I found all of this when I arrived on a Friday evening in April, after a 4-hour drive, with a cooler full of food and absolutely no patience left. The crunch of those spike strips under my rear tires, the flat pop of rubber giving, is a sound I will not forget. I sat in my truck for a solid 5 minutes in the middle of that logging road, both rear tires hissing, just staring at the fence. Sterling's fence, because let's be clear, it was his fence now, not an HOA fence. I would confirm this later. Ran from the corner of his property line, diagonally across my driveway access, and anchored into what was, by any reasonable survey, my land. It was chain link, 6 feet tall, topped with that little angled arm of barbed wire that says, "I mean business," in the language of men who are compensating for something. There was a padlock on the gate, my gate, on my driveway. I got out of the truck. The evening air smelled like rain coming in over the ridge, that electric iron and pine smell that the mountains get before a storm. Frogs were starting up in the creek bed below the property. Under different circumstances, it would have been a gorgeous evening. I walked the fence line, took pictures, lots of pictures. Then I took video, narrating the boundary markers I could identify. The old iron pin in the oak tree root that Eldon had set in 1961, the concrete survey marker near the road, and the clear, obvious fact that Sterling's fence crossed both of them. Then I drove back down to the main road on a flat rear tire and called a tow truck, because I was not going to let anger make me do something stupid. Not yet. Here's the first thing I did right. I did not confront Sterling that night. I know that sounds like restraint. It wasn't entirely. It was calculation. When I called my cousin Vaughn, a paralegal in Asheville who has helped me with property questions before, he said 6 words that became my operating principle for the next 48 hours. Don't argue, document, then bury him. The next morning, I drove back up the mountain with my brother-in-law Colt, a contractor who has been doing surveying work in western North Carolina for 20 years. Colt brought his own survey equipment, a total station transit, the kind that would make Sterling's hired surveyor look like he'd been using a tape measure and a guess, and we spent 3 hours re-establishing every boundary marker on my parcel. What Colt found was clarifying. Sterling's fence didn't just nick my driveway. It encroached 14.3 feet into my property at its deepest point. The spike strips, 6 of them, the commercial-grade kind that trucking companies use for lot security, were buried in my gravel, on my land, which means Sterling had committed what the law calls trespass to land, and, more critically, conversion of property, the legal term for when someone exercises control over your stuff as if it's theirs. The spike strips themselves, because they damaged my vehicle, opened a door to a civil claim for property damage. Takeaway: documenting encroachment with a licensed survey before confrontation turns a neighbor dispute into a legal case. I also called the county recorder's office that morning. I wanted to see exactly what paperwork Sterling had filed. The clerk, a woman named Ms. Bird, who sounded like she had heard everything, pulled the filing for me. It was a Notice of Adverse Claim to Common Area Driveway Access, a document Sterling had apparently drafted himself, or had someone draft for him, and filed with the HOA rather than with the county. He had also sent a copy to the county recorder, but it had been received and stamped, not recorded. There's a meaningful difference. This isn't a deed, Ms. Bird told me. This is a piece of paper someone mailed us. Now here's where Sterling made his first catastrophic mistake, the kind that only men who have never been wrong about anything make. That evening, he came over. He walked across the fence line, through the gate that he had padlocked, using a key he had, onto my property, where Colt and I were still working, and he told me, in front of Colt, in a voice that was loud enough for the birds to hear, that I needed to accept the new arrangement, and that if I made trouble, he would have the HOA fine me into foreclosure. Colt was writing notes on a survey form. He kept writing. "You want to say that again?" I asked Sterling. I wasn't angry. I was something better than angry. I was attentive. Sterling said it again. Colt wrote it down, including the time. 6:47 p.m., Saturday, April 14th. A verbal threat to use HOA fines as a financial weapon, made in front of a witness and subsequently written into a contractor's field notes, is a gift. I didn't know yet exactly what I was going to do with it, but I kept it. Sterling went back through his gate, clicked the padlock, and I heard him whistle as he walked away, confident. That whistle was the sound of a man who had never lost. I took a picture of the padlock. Monday morning, I called an attorney, not a general practice guy. I specifically wanted a real property attorney with HOA litigation experience, the kind of lawyer who gets a certain gleam when they hear the words adverse claim and pre-existing parcel. I found her through a referral from Colt, a woman named Philippa Holt, based in Asheville, who had been practicing property law for 19 years and had a framed cross-stitch on her office wall that read, "Possession is 9/10 of the law. The other 10th is documentation." I liked her immediately. Philippa reviewed the survey data, the photos, the filed notice, and Colt's field notes in about 40 minutes. Then she leaned back in her chair and said something that I have thought about many times since. Sterling Briggs filed a document that has no legal force, encroached on your property with a physical structure, damaged your vehicle, and then verbally threatened you with financial harm in front of a witness. He has handed you a personal injury claim, a trespass claim, a conversion claim, and potentially a claim under North Carolina's Unfair and Deceptive Trade Practices statute, if we can show the HOA acted in concert with him. She paused. Does he have money? I told her I didn't know. She said we'd find out. Here's the second legal/financial trick Sterling didn't know I had access to. Public records on HOA finances and individual homeowner lien history. In North Carolina, HOA financial records, including liens filed against member properties, are accessible through the county recorder, and, if the HOA is incorporated, through the Secretary of State's business filings. Philippa sent a paralegal to pull Sterling's full lien history within 24 hours. What came back was illuminating. Sterling had 2 HOA assessment liens against his own property, meaning he was behind on his own HOA dues, not by a little, by 11 months. The HOA had filed the liens quietly, presumably because Sterling was the board president, and had some degree of control over how aggressively they were pursued. But the liens existed, they were public, and they meant something very specific under North Carolina HOA law. A board president who is delinquent on assessments is, in most HOA bylaws, ineligible to hold office. Takeaway: HOA financial records and lien filings are public. A delinquent board president may be legally disqualified from their position under the association's own bylaws. Meanwhile, back at the cabin, things were escalating. Tuesday morning, I got a certified letter from the Ridgeline Estates HOA, not from Sterling personally, but on official HOA letterhead, informing me that my property had been assessed a $1,500 fine for obstruction of common area maintenance access, and that failure to pay within 30 days would result in a lien being filed against my parcel. The irony of this was almost theatrical. The HOA, run by the man who had just encroached on my land, was fining me for obstruction. I called Darlene. She had gotten a letter too. So had a man named Wendell, who owned the lot on Sterling's other side, and had been in a dispute with him for 2 years over a retaining wall. Wendell is 71 years old, a retired electrician, and he has the energy of a man who has been waiting for someone to show up with a plan. When I called him, he answered on the first ring. "I've been keeping a file," Wendell told me. His file contained 3 years of HOA meeting minutes. He attended every meeting and took his own notes. A photograph of Sterling accepting what appeared to be a contractor kickback at a community project site. 2 written complaints he'd submitted to the HOA that had never received a formal response, and a copy of the original Ridgeline Estates CC and Rs, the Covenants, Conditions, and Restrictions document, the foundational legal document of the HOA, which Wendell had obtained directly from the county recorder's office when the development was first platted. Wendell had been building this file for 36 months, waiting for someone to use it. "I figured eventually somebody would fight back," he said. There was no smugness in his voice, just patience. I drove to his house that afternoon. He had the file organized in a 3-ring binder with color-coded tabs. I brought coffee. We sat at his kitchen table, the air inside his house smelling like motor oil and old newsprint, a ceiling fan turning slowly overhead. And I went through every page while Wendell talked me through the context. By the time I left, I had a roadmap. Sterling Briggs had been running a one-man protection racket inside a homeowners association, and he had been doing it for 4 years because nobody had assembled the pieces before. Now someone had. Wednesday. Sterling found out I'd hired a lawyer. I know this because he called me. Actual phone call, which I let go to voicemail, and left a message that I can only describe as a masterclass in barely contained panic, trying to sound like calm authority. He said that I was making a mistake by escalating, that the HOA had every right to manage access infrastructure, and that he hoped we could resolve this neighbor to neighbor, after the fence, after the spike strips, after the certified fine letter. I saved that voicemail, sent a copy to Philippa within the hour. Then Sterling tried something smarter, which told me he'd gotten advice from someone. He had the HOA's contracted property management company, a firm called Blue Ridge Community Services, send me a formal dispute resolution offer. They would remove the spike strips and temporarily suspend the $1,500 fine if I agreed to sign a document acknowledging the HOA's right to regulate access to the common driveway corridor. That phrase, common driveway corridor, was doing a lot of work. If I signed it, I would be acknowledging that my driveway was HOA common area, which it wasn't, which it never had been. My driveway existed before the HOA existed. Philippa took one look at the offer and called it a waiver dressed as a settlement. She wrote back declining it and attaching our survey data, Colt's field notes, a formal notice of the trespass and conversion claims, and a demand for the fence and spike strips to be removed within 72 hours, or we would seek an emergency injunction. Sterling's response was to call an emergency HOA board meeting. Here's where Darlene becomes important again. The Ridgeline Estates HOA bylaws required that any emergency board meeting be noticed to all homeowners at least 48 hours in advance, and the notice had to be posted at the community mailbox cluster as well as distributed by email. Sterling sent an email at 11 p.m. on Wednesday night, which arguably satisfied the electronic notice requirement, but he did not post at the mailbox cluster. Darlene noticed. She called me at 7 a.m. Thursday. "There's no notice on the board," she said. The meeting was scheduled for Friday evening. If the notice requirement wasn't met, the meeting, and any votes taken at it, would be procedurally invalid. Darlene photographed the empty notice board at the mailbox cluster every morning and evening, from Wednesday through Friday, time-stamping each photo on her phone. 32 photographs, total. Methodical, quiet, devastating. Takeaway. HOA meeting notice requirements are enforceable. Actions taken at improperly noticed meetings can be voided, and photographic documentation of a missing notice is legally meaningful. Meanwhile, I had been doing some research of my own on Sterling specifically. Public records in North Carolina include not just property liens, but also civil court filings. And when I ran Sterling Briggs through the Buncombe County Civil Court Index, I found something that Philippa called the cherry on top. Sterling had been sued 3 years earlier by his former employer, the insurance company he'd worked for before moving to Ridgeline Estates, for breach of a non-compete agreement. The case had settled, confidentially, but the initial filing described the underlying allegations in enough detail to establish a pattern. Sterling had taken client lists, diverted business, and then used the settlement money, combined with a refinanced mortgage on his Ridgeline Estates property, to fund the lifestyle he was now living. His mortgage, I learned from public records, was underwater. He owed more on his house than it was worth. The 2 unpaid HOA assessment liens were small compared to the broader picture. Sterling Briggs was broke, operating on borrowed credibility, and the HOA board presidency was the only throne he had left. That context changed how I thought about him. Not sympathetically, he'd blown past the point where I felt sympathy, but strategically. A man with nothing left to lose is dangerous. A man who is terrified of losing the one thing he still has is predictable. I knew what Sterling was going to do next before he did it. He was going to try to make me look like the problem. Sure enough, by Thursday afternoon, 2 things happened. A post appeared on the Ridgeline Estates neighborhood Facebook group claiming that my cabin was a code violation hazard, and that I had been threatening neighbors, and Sterling had apparently reached out to at least one other board member to drum up support for a vote to formally condemn my property and refer it to the county building inspector. The Facebook post was anonymous, but the account that made it had been created 3 weeks earlier and had no other posts. Colt noticed the account had liked Sterling's personal Facebook page. He took a screenshot. Thursday night, Philippa called me at 9 p.m. She had been going through the original Ridgeline Estates CC&Rs, the founding covenant document that Wendell had obtained, and she had found something. Her voice had that particular quality that lawyers get when they're being careful not to sound as excited as they are. "Garrett," she said, "your cabin is not subject to the HOA at all." I asked her to say that again. She did. Here is what she had found, and this is important, so I'm going to explain it clearly. When Ridgeline Estates was platted in 2002, the developer recorded the CC&Rs against all lots within the subdivision plat. A plat is the official map and legal description of a subdivision. My parcel, Eldon's original 3 acres, was never part of the subdivision plat. It was an adjacent, pre-existing parcel that happened to share a road access point with the development. At some point, likely when the HOA management company updated their records in 2018, my parcel had been added to the HOA's internal membership database. Incorrectly. Without my consent and without any legal mechanism that would make that addition binding. I had been paying HOA dues for 6 years on a parcel that was never legally subject to HOA covenants, which meant every fine, every notice, every administrative action Sterling had taken against my property, including the adverse claim filing, had zero legal foundation. More than that, Sterling's fence, which he had partially justified in the adverse claim notice by referencing HOA authority over common corridor access, lost its only colorable legal basis the moment the HOA's jurisdiction over my parcel collapsed. There was no common corridor. There was no HOA authority. There was just a man who had built a fence on my land. And there was one more thing. The CC&Rs contained a specific provision, Section 14.3, which Wendell had dog-eared in his binder without knowing exactly why it mattered, stating that any HOA board member who filed a false or fraudulent claim against a member's property could be removed from the board by a 2/3 vote of the membership, and would be personally liable for the costs incurred by the affected member in defending against the claim. Sterling had filed an adverse claim against a parcel the HOA didn't have jurisdiction over, using HOA authority he was exercising while personally delinquent on assessments, after being improperly maintained in office because his disqualifying delinquency had never been reported to the membership. Section 14.3 was a loaded gun, and Sterling had handed it to me. Philippa said we needed to move fast before the Friday meeting. I agreed. I called Wendell and Darlene. Then I made 2 more calls, one to a local journalist named Orrin Trask, who covered municipal and community governance for the regional paper. I had met him once at a county commissioner meeting and remembered he had a particular interest in HOA overreach stories. And one to the NC Real Estate Commission, which licenses property management companies and has authority to investigate HOA management firms that facilitate improper actions. By midnight Thursday, the pieces were in place. Sterling was going to walk into a Friday evening meeting, thinking he was consolidating power. He had no idea he was walking into the last room he'd ever preside over. Friday morning felt different from the moment I woke up. I was staying at a motel in the valley. The cabin was technically still inaccessible with the fencing in place, and I sat at the small desk with a cup of gas station coffee and a yellow legal pad, and I made a list of every moving part. There's something almost meditative about a plan that has fully come together. The coffee was terrible. I didn't care. Let me walk you through what we were setting up, because each piece is worth understanding on its own. The first track was legal, the injunction and the claims. Philippa had filed for an emergency temporary restraining order, TRO, in Buncombe County Superior Court on Thursday afternoon, based on the trespass, the conversion claim, the documented property damage from the spike strips, and the encroachment survey data from Colt. A TRO in a property trespass case can be granted on an expedited basis when there's documented, ongoing, physical interference with the plaintiff's property rights. The judge had reviewed the filing and set a hearing for Friday afternoon, before the HOA meeting. Philippa had also attached a motion to void the adverse claim filing as legally baseless. If the TRO was granted, Sterling would be legally required to remove the fence and spike strips before the HOA meeting even started. Takeaway: an emergency TRO for property trespass can be filed and granted within 24 to 48 hours, when physical encroachment is documented with survey data and photographs. The second track was the HOA itself. Philippa had drafted a formal notice, sent by certified mail Thursday afternoon, and also delivered in person by Wendell, to every homeowner on his block, informing the membership of Sterling's delinquent assessment status, his legal disqualification from the board presidency, and the improperly noticed emergency meeting. The notice included a petition for a special membership vote, as allowed under the CC and RS, to remove Sterling from the board under Section 14.3. By Friday morning, Wendell had signatures from 14 homeowners, more than enough for the 2/3 threshold on a removal vote. The third track was the property management company. I had filed a complaint with the NC Real Estate Commission on Thursday evening, attaching documentation showing that Blue Ridge Community Services had transmitted the improper adverse claim notice and the $1,500 fine assessment on behalf of a board member who was ineligible to authorize those actions. The commission had acknowledged receipt and flagged it for review. I had also called Blue Ridge Community Services directly, calmly, factually, and informed their office manager of the pending complaint and the forthcoming TRO. The office manager, to her credit, put me on hold for 4 minutes and then came back to tell me that Blue Ridge was reviewing its relationship with the Ridgeline Estates account. I took that as a sign. The fourth track was Orrin Trask, the journalist. He wasn't a weapon. I want to be clear about that. I hadn't called him to embarrass Sterling publicly out of spite. I called him because what Sterling had been doing to 3 or 4 homeowners over 4 years was a story with community relevance, and people in that development deserved to know. Orrin had agreed to come to the HOA meeting as a member of the press, covering a matter of public interest. He would be there with a notebook and a camera. Now here is the physical piece. The thing that I think people remember most when I tell this story in person. The spike strips. Sterling's spike strips were installed on my gravel driveway. They were physically on my property. Once the TRO was granted, their continued presence would be contempt of court. But even before the TRO, I had a right to document and photograph them in detail. And Colt had done exactly that, including measuring their precise placement and photographing the brand name on one of the strips, a commercial-grade model typically used by parking enforcement contractors, available on a major industrial supply website for about $340 per strip. Colt had also photographed the installation, fresh gravel displacement, screw anchor holes drilled into my driveway bed, in a way that established this wasn't a casual placement. Someone had installed these deliberately, professionally, and recently. I had that installation photographed, documented, and attached to the TRO filing. 6 spike strips, each documented, each on land I owned, each a separate instance of conversion of property. The math on a civil damages claim was becoming interesting. At 2 p.m. Friday, I put on a clean shirt, drove to the courthouse, and sat in the gallery while Philippa argued the TRO before a judge who spent most of the hearing looking at the survey overlay photographs, with an expression that I can only describe as controlled incredulity. The hearing took 22 minutes. We won. Sterling found out about the TRO at approximately 3:30 p.m. Friday, which I know because Darlene, who lives 3 houses down from him, watched a white truck from Blue Ridge Community Services pull into his driveway, stay for 8 minutes, and leave. Shortly after, she heard what she described to me as a very loud conversation happening inside that house. I was on the phone with Philippa when Darlene texted me this information. Philippa said simply, "Good, he's rattled." A rattled Sterling Briggs, it turned out, was a creative Sterling Briggs. In the 2 hours between the TRO and the HOA meeting, he made 3 moves. The first move, he called 2 other board members, a couple named the Fernalds, who had always voted with him, and apparently convinced them that the TRO was a personal civil matter that had nothing to do with HOA governance, and that the meeting should proceed as planned. This was legally incorrect. The TRO specifically enjoined any HOA enforcement action against my parcel pending the full hearing. Sterling was telling his allies that a court order didn't apply to his meeting. The second move, he called Wendell directly. I learned this from Wendell himself, who recounted the conversation with the serene satisfaction of a man who has been waiting for this exact phone call for 3 years. Sterling apparently offered to drop the whole thing if Wendell withdrew the Section 14.3 removal petition and convinced me to agree to a mutual non-disparagement clause. Wendell told him he needed to think about it. Then Wendell called me and laughed for about 45 seconds.
"He's offering peace terms," Wendell said. "That's not what people do when they think they're winning." The third move was the most revealing and the most reckless. Sterling contacted the county building inspector's office Friday afternoon and filed a complaint alleging that my cabin had unpermitted construction and posed a safety hazard. He did this, I believe, hoping that a building inspection notice would muddy the legal waters and give him something to point to at the meeting. What he didn't know, because he hadn't done the research, was that my father had pulled proper permits for the 1987 edition. I had copies. My propane hookup had been permitted in 2019. I had that paperwork too. Every modification to that cabin had been done by the book, because Eldon Marsh had raised a family that did things by the book, and that ethic had been passed down. The building inspector's office called me Friday afternoon to schedule an inspection. I told them I would welcome it. I sent them the permit documentation within the hour. The deputy inspector I spoke with, a practical-sounding woman named Ms. Holloway, said, "Okay, well, it sounds like your records are in order. We'll close this out." Another door Sterling thought he'd opened turned out to be a wall. By 6 p.m., the sun was cutting low through the ridgeline, casting that long amber light over the Blue Ridge that makes everything look like a painting. I drove up toward the community center where the HOA meeting was held, a converted barn that smelled like cedar and old folding chairs, and parked next to Orrin Trask's car. He had his recorder out already, testing the battery. Wendell was standing outside the door with his 3-ring binder under his arm, wearing a freshly pressed shirt. When he saw me, he nodded once. Darlene was already inside, saving seats. I stood outside for a moment and looked up at the ridge. Up there, behind the tree line, was my cabin. Eldon's cabin. The air was cool and smelled like wood smoke from somewhere up the hollow. A whippoorwill was calling in the early dark. 48 hours earlier, I had driven up that road and blown 2 tires on a man's spite. Tonight, I was going to walk into that room and end his tenure. I opened the door. The community center was fuller than usual. Word had gotten around. The certified letters, Wendell's petition, Orrin's presence. And there were maybe 40 people in folding chairs instead of the usual 12. Sterling was at the front of the room behind a folding table, in a polo shirt, with a gavel and a printed agenda. His jaw was tight. His eyes found me the moment I walked in. He picked up the gavel. I sat down next to Darlene. She passed me a butterscotch candy, the kind she always kept in her coat pocket. I unwrapped it as quietly as I could. Let's get started, I thought. Sterling called the meeting to order at 6:15 p.m., with what I can only describe as theatrical composure, the performance of a man who believes that if he acts like nothing is wrong, nothing will be wrong. He moved to call roll and establish quorum. Wendell immediately raised his hand. "Point of order," Wendell said. "Before we begin, this meeting was not properly noticed under Article 7 of the bylaws. The physical posting requirement at the mailbox cluster was not fulfilled. I have 32 time-stamped photographs documenting the absence of a notice from Wednesday through this afternoon. I am formally objecting to this meeting's validity and requesting it be adjourned." Sterling's response was smooth. I'll give him that. He said the email notice had been timely sent, and that, in the modern era, electronic notice had superseded physical posting. He cited no authority for this interpretation. There was no citation because none existed. Philippa, who had joined us by phone, and whose voice was now coming through a small Bluetooth speaker I placed on the seat beside me, which, yes, got some looks, said clearly into the room. The bylaws do not contain a substitution clause for electronic versus physical notice. Both are required. This is an improperly noticed meeting. Sterling said that outside legal counsel was not a recognized participant in board proceedings. Philippa said that as legal counsel for a member challenging the validity of the proceedings, she had a right to be heard on procedural matters. She cited the specific subsection of the NC Nonprofit Corporation Act that governs HOA meeting procedures. The Fernalds, at Sterling's side, exchanged a glance. Sterling moved to table Wendell's objection and proceed with the agenda. He called for a show of hands from the board. The Fernalds raised theirs. It was 3-0. He moved on. This was, Philippa had told me beforehand, exactly what we hoped he would do.
Any action taken at this meeting, any vote, any resolution, any enforcement motion, would be procedurally voidable precisely because he had overruled a documented procedural objection. He was building our appeal for us in real time. Sterling moved through 2 agenda items quickly, both of them designed to formally ratify his adverse claim against my property and authorize a lien filing. He called for board votes. The Fernolds complied. Wendell voted no on both. Then Sterling made his play. He introduced a new agenda item, not on the distributed agenda, entitled Emergency Community Standards Enforcement, Parcel 7B. Parcel 7B was my cabin. He proposed an emergency resolution directing the HOA's management company to initiate county code enforcement proceedings against my property and to place a lien on my parcel for unpaid fines, totaling $4,200. The original $1,500 plus new fines he was apparently inventing in real time. That's when I stood up. "Mr. Briggs," I said, "I'd like to note for the record that you are currently subject to a temporary restraining order entered this afternoon by Buncombe County Superior Court, enjoining any HOA enforcement action against my parcel. Proceeding with this vote would constitute contempt of court. Additionally, I'd like to note that under Section 14.3 of these CC&Rs, you are personally liable for costs incurred by a member in defending against a fraudulent HOA claim, and I have incurred substantial costs. I also want to note that you are 11 months delinquent on your own HOA assessments, which, under Article 4, Section 2 of the bylaws, renders you ineligible to hold board office. We have the lien records." The room was very quiet. I set a copy of the TRO on the table in front of him. Colt had printed it on bright white paper. It landed with a small, clean sound. "I also have a petition here, signed by 14 homeowners, calling for a removal vote under Section 14.3, Wendell said from his seat, holding up his binder. "That's 23% of the membership. The threshold for a special vote is 15%. Sterling's composure lasted about 4 more seconds. Then it didn't. He said several things that I won't repeat in full, but they included the phrase, "This is my association," which Orrin Trask, in the second row, wrote down and later quoted directly in his article. The Fernolds stood up and quietly moved their chairs away from Sterling's side of the table. Not dramatically, just away. Mrs. Fernald said, softly, "Sterling, stop." He didn't stop immediately, but he slowed. And somewhere in that moment, the cedar smell of that old barn, 40 people watching in silence, a journalist's pen moving, Sterling Briggs understood that the game had changed. Here is the image I want you to hold in your mind. 6 commercial-grade spike strips, each one roughly 3 feet long, black rubber and steel, lying on my gravel driveway in the evening light, and a county sheriff's deputy standing next to them, documenting their presence with his own phone camera. Because that is exactly what happened at 7:45 p.m. Friday night. When Sterling's meeting devolved, and it devolved quickly after Wendell presented the petition, and Philippa's voice explained, again, that any vote taken tonight was procedurally voidable, and that Sterling was potentially in contempt of an active court order. Sterling did something that I genuinely did not fully anticipate. He adjourned the meeting. Not gracefully. He picked up the gavel, said, "This meeting is adjourned," and walked out. He walked out past 40 homeowners, past Orrin Trask and his recorder. He got into his car and drove up the hill, toward my cabin, toward the fence. Wendell grabbed my arm. "Don't go up there alone." I called the Buncombe County Sheriff's non-emergency line. I explained that I had an active TRO, that the respondent had just left a meeting under adversarial circumstances, and that I had reason to believe he might attempt to interfere with my property in violation of the court order. The dispatcher connected me to a deputy who was 20 minutes out. I stayed at the community center with Wendell and Darlene and Colt, and we waited. The deputy, a composed, unhurried man named Deputy Holcomb, arrived at the cabin road at 7:40 p.m. I drove up with him. Sterling's car was there. Sterling was standing at the fence line with what appeared to be a pair of bolt cutters, seemingly contemplating whether to remove the padlock and go onto my property. He had not done so yet. He was just standing there. Deputy Holcomb pulled up, stepped out, and approached Sterling with the calm of a man who has seen every flavor of neighborhood dispute and is not impressed by any of them. He asked Sterling to identify himself. Sterling did. Deputy Halcombe had the TRO number. Dispatch had already pulled it. He read Sterling the relevant provision. Respondent is hereby enjoined from any further physical entry upon, construction on, or interference with plaintiff's described parcel pending hearing. Sterling said the TRO was under appeal. It was not under appeal. Deputy Halcombe explained this. Then he asked Sterling to step back from the fence. This is the moment. This is the image I promised you. Sterling Briggs, polo shirt, bolt cutters in hand, standing on a gravel road in the Blue Ridge dark, stepped back from a fence he had built on my land, while a deputy sheriff stood between him and the padlock, and the headlights of Colt's truck illuminated those 6 spike strips lying across my driveway in a perfectly clear, perfectly documented display of what one man's pettiness looks like when it finally meets a consequence. Orrin Trask had followed us up the road. He took a photograph. It appeared in the next day's regional paper above the fold. The fence, the spike strips, the deputy, and Sterling in the background with the bolt cutters hanging at his side. The caption read, HOA board president served with court order at disputed property line. Deputy Halcombe documented the spike strips, still on my land, still in violation of the TRO, as evidence of an active encroachment. He took a full report. Sterling was not arrested that night, but he was served with formal notice that any further interference would result in a contempt of court charge. Sterling drove away. I stood there in the dark with Colt and Wendell and Darlene, listening to his taillights disappear down the road. The frogs were going again in the creek. Somewhere up in the tree line, a screech owl called once. Darlene said, "Well?" Colt laughed. Wendell laughed. I laughed. We stood there on my grandfather's land, on Eldon Marsh's 2.3 acres, and we laughed in the dark like we'd all needed to for a while. The following morning, a crew arrived to remove the spike strips in the fence, court-ordered, supervised by Deputy Halcombe, and as each strip came up from my gravel, I photographed it. 6 photographs. 6 pieces of evidence for the civil damages hearing. At 10 a.m. Saturday, the Ridgeline Estates HOA Management Company, Blue Ridge Community Services, sent a written notice to all homeowners that they were terminating their contract with the association, effective immediately, citing governance irregularities. At 2 p.m. Saturday, the 2 remaining board members, the Fernalds, sent their own letter to the membership, announcing they were calling a special election to reconstitute the board. Sterling Briggs had not yet responded to any of it. He didn't need to. The story was already over. The special election happened 3 weeks later. Sterling did not run. He couldn't. The membership had formally voted, at a properly noticed meeting, to remove him under Section 14.3, with a final tally of 31-2. The 2 who voted against removal were later confirmed to be Sterling himself and, inexplicably, a man named Gerald, who apparently hadn't been following the situation and just voted no on principle. Gerald later apologized. The new board was seated within a month. Wendell as president, Darlene as treasurer, and a young woman named Priya, who had moved in the previous year and had a background in nonprofit governance. First order of business: a full audit of HOA finances for the previous 4 years. The audit, conducted by an independent CPA, found $11,400 in assessment fees that had been improperly credited, delayed, or misdirected during Sterling's tenure. The association's legal counsel sent demand letters. My civil case was settled 4 months after the incident. I'll keep the specific terms private, as the settlement agreement requested, but I will tell you that the damages covered my attorney's fees, my vehicle repair, the 2 replacement tires, and enough additional compensation that I was able to fully winterize the cabin, new insulation, a proper heating system, and a wood stove that Eldon would have approved of. Sterling Briggs lost his home 8 months after the meeting. The mortgage lender, apparently spurred by the public coverage of the HOA situation and a closer look at the property's lien status, accelerated the foreclosure proceedings that had been quietly pending. He moved out on a Tuesday. Darlene told me she saw the moving truck. She said she didn't feel good about it exactly. "I don't wish him harm," she said. "I just didn't want him to have the power anymore." That's the right way to feel about it, I think. This was never about destroying a man. It was about removing someone from a position of authority he was using to harm people who had less recourse than I did. The homeowners who had paid fines under Sterling's illegal assessments, 2 of them elderly, 1 of them on a fixed income, received refund checks from the HOA audit. That mattered more than anything else. The cabin is still there.
I was up last October with my youngest, who is 17 and has never shown much interest in the place, but who spent an afternoon helping me re-chink the old mortar on the cinder blocks Eldon had laid. We didn't talk much, just worked. The ridge was full of color, maple and hickory and sourwood going red and gold in the October light. And when we stopped for lunch and sat on the porch with sandwiches, my kid looked out at the trees and said, "I get why you fought for this." Yeah, me too. Now here's the practical part, because I know some of you are in your own version of this story right now. 3 things to remember. 1. Pull your HOAs, CC, and Rs from the county recorder and read them. The real document, not the summary the management company gives you. The actual legal text, section by section. Your antagonist is almost certainly in violation of something in there. 2. Your property's history is your greatest asset. Pre-existing parcels, prior permits, original survey data. These are your evidence before anyone has done anything wrong. File them somewhere safe. 3. Before you confront anyone, document, document, document. Survey data, photographs, time-stamped field notes, witness statements. Build the case first, then let the case do the talking. The Ridgeline Estates HOA, under Wendell's leadership, started a small scholarship fund this year for graduating seniors from the local county high school who are pursuing trades or technical education. Electricians, carpenters, surveyors, contractors. The first award was $2,500. They named it the Eldon Marsh Community Trades Award. I did not suggest the name. That was Wendell's idea. I cried a little when he told me. I'm not ashamed of that.
That's what happened to Garrett. He didn't win because he got lucky. He won because when Sterling planted the spy strip on someone else's land and waved his spear like he's already won, Garrett got quiet. Quiet people with the right documents are the most dangerous thing a bully will ever face. One survey, one attorney, one three-ring spider a 71-year-old retired electrician has been building for 3 years, waiting for someone to finally show up and use it. The fence came down by court order. The presidency went down by a vote of 31-2, and Eldon Marsh's cabin is still standing. Here's the things I want you to walk away with. Your paperwork is your property line. Know your CCNRs, know your survey markers, because people like Sterling are counting on you not knowing. Have you ever had an HOA or anyone with a little borrowed authorities try to take something that was yours? Drop it below. I read everyone. Share this with someone who needs to hear it, and subscribe because next time we got a veteran, a flagpole, and a federal law that ended an HOA winning streak code. Around here, we believe one thing: play stupid games, win stupid prizes.